Well, I will stand in. This is the first meeting of the Merchant Shipping Seafarers Amendment Bill 2013. Any nomination, Chairman, please?
仲有冇第二個
Mr. Kwok-kin. Any seconder? Yes. Any other nomination, please? No. So, well, I accept the nomination. Thank you very much.
而家係知好咁啊，接住落嚟想問大家需唔需要
You need a vice chairman? Probably not. Let's make it simple. Now, after the closing date, we have received a letter from Mr. Ho Chun-yin. He wants to join the Bills Committee. I just want to know whether members agree to accepting Mr. Ho, a representative of the Agriculture and Functional Fishery constituency. Any comments? Do you agree? Okay, I see heads nodding, and there is no objection, so welcome, Mr. Ho. All right, now next on the agenda is meeting with the administration. So let us invite the officials in. Welcome.
今日出席我哋呢個委員會嘅
The officials attending our meeting today are Ms. Jenny Chan, PAS Transport and Housing Bureau, Mr. Jason Lam, Assistant Secretary, Mr. Y.M. Cheng, Chief Marine Accident Investigation and Shipping Security Policy of the Marine Department, General Manager, Ms. S.F. Wong, Shipping Registry and Seafarers, from the Department of Justice, Ms. Maple Chang, Senior Government Counsel, and Ms. Carmen Chen, Government Counsel.
我哋係咪請政府當局咧係先介紹一下
So shall we invite the administration to brief us on the amendment bill first? Thank you, Chairman. Let me just brief you on the background and our major recommendations. Hong Kong is one of the biggest shipping register in Hong Kong, and we have all along been endeavoring to implement international conventions. As for the working conditions of the workers, we implemented through the Merchant Shipping Seafarers Ordinance. In 2006, the ILO endorsed the Maritime Labor Covenant 2006. With regard to the working and accommodation and working conditions in ocean-going ships, there are minimum requirements set forth. And in order to enable the requirements under the MLC, so as to make local provisions in the law in line with international convention, we've consulted the ship owners associations and seafarers associations. And we have two parts of amendments. The first part is the amendment bill, which is to amend the Merchant Shipping Seafarers Amendment definition of seafarers. And there are also other technical amendments. And upon the endorsement of this bill, enactment of this bill into law by this Council, we will submit in the next stage subsidiary legislation in respect of implementing the details in the Maritime Labor Convention. This is to amend existing laws and subsidiary legislation. With regard to the amendment to the definition of seafarers, that will include anyone working on board. That is in line with the MLC. But in the law, we will provide for a schedule listing several categories of people who are not regarded as seafarers, including the pilots, the ship owners, the managers, charterers, law enforcement agents, law enforcement officers. As for this exclusion list, we have consulted representatives of ship owners and seafarers, and they have no objection to that. The second major amendment is to allow seafarers organizations to provide seafarer recruitment and placement service. At present, a company can apply for a permit from the Marine Department so that it could engage in the business of recruiting, supplying seafarers, so that seamen can be placed to their ships. But seafarers organizations such as sailors' unions are not allowed to do that. Now we propose that the seafarers organizations having obtained a permit can provide such a service. The third major proposal is to make use of the direct reference approach in making subsidiary legislation and the ordinance in the future for implementing requirements and the national agreements applicable to Hong Kong. There are quite a lot of such amendments from time to time. By the direct reference approach, we can apply the latest international requirements to local laws. We have already consulted representatives of seafarers and ship owners, and they support that. We also, in November last year, consulted the LAB and also the Economic Affairs Panel of the LegCo last year. So much for introduction. Thank you. Members, any questions? Mr. Tang, and then Ms. Yik. Sorry, speakers not coming through. This may not have a very great impact on society at large, but this is very important to the seafarers. I hope that the groups some groups should be invited. It may be a few ship owners associations and a few seafarers unions or sailors unions. And now this is the amendment bill, which is about the framework. And I hope that we can hear directly from the horse's mouths concerning parts that have not been covered in the main body of the ordinance. As for the 14 areas of the MLC that are they all included in the bill, or has there been any selective adoption? I just want to know whether you have just adopted 8 of the 14. So it seems that you say that they apply to Hong Kong. So are there other things in the MLC which are not applied to Hong Kong? And as for the seafarers organizations, are they only limited to trade unions, or you also include a charitable organizations, any body corporate or cooperatives, or just seafarers unions? As for the 170 registered seafarers in Hong Kong, do you include those serving on board Hong Kong and Macau ferries? Now, for those who engage in day trips on board, how are these seafarers protected? And in fact, the Hong Kong Sailors Union have reflected their view. They said that they wanted to have something in relation to collective bargaining and retirement protection. They expressed their disappointment for the absence of such provisions in the bill. As for the need for public consultation, I will seek members' advice later. I don't know whether the officials have remembered all the questions asked by Mr. Tang. There's a barrage of questions. It's better to ask or shoot the questions one by one. The PAS. As for the convention, China is a signatory to the ILO, and it is involved in passing or rather signing the MLC. I know that they have yet to implement it in the mainland. Now, once we are ready, we can inform the authorities, and then the law will come into effect. Whether we just selectively apply the convention, the answer is none. The answer is the negative. All the requirements in the convention that needs implementation by means of passing laws are all in this bill. This is to meet the MLC. This is to enable the Marine Department to issue permits. The 14 areas and the relevant requirements will be in the subsidiary legislation. As for the permitted bodies, in respect of seafarers' recruitment and placement, if they are seafarers' organizations, the mission or the articles of the association or constitution should include that. Otherwise, there is no further restrictions. As for the convention is to protect seamen working on board of vessels for international voyage. So the Hong Kong Macau ferries or the seafarers working on Hong Kong Macau ferries are not covered. Under Cap 478, there are certain provisions which are applicable to cross-boundary ferries, but the present amendment is not applicable to sailors working on cross-boundary ferries. As for collective bargaining, the MLC does not require its signatories to legislate on collective bargaining, and therefore the present amendment does not include that. In fact, we have consulted the shipowners and seafarers associations, and they have no strong views on that. Thank you. Mr. Yik. Thank you, Chairman. Basically, I support the legislation. This will be an improvement to serving seafarers. I just want to ask a few simple questions concerning miscellaneous Amendment M. Is it there in the present law? The regulation made under the section may allow seafarers to allot all their wages to the persons nominated by them. Now, the sailor can say designate the wages to their relatives or family members. This is an existing provision, right? Yes, indeed. The existing ordinance provides that the sailor can state, say, for a certain part of his wage can be allotted to a nominated person. This is only part of the allotment. So the difference is part or whole. Okay, then N. Now, if the government is to repatriate a seafarer, the cost incurred is a liability of the employer, and the means is detaining the ship of the employer, owned by the employer. Well, in the past, there was no such clear provision. Now, we want to add this provision. Say, if any cost is incurred for repatriation of the seafarers, then the government can detain the ship.
Mr. Poon Xiaoping, to be followed by Mr. Sin Chung Kai. The speaker is not coming through. I will support the bill because the committee under the LAB has already discussed this issue. Following on Mr. Tenkabiu's question, cross-boundary vessels will not be subject to the bill. What about gambling vessels sailing to open waters? Will they be subject to the regulation of this bill? Yes, Marine Department. Thank you, Mr. Poon, for your question. We have cruises to nowhere. The big vessels, they're registered overseas, and they are overseas. They fulfill offshore vessel specifications, so they are regulated. So ships with destination in the PRD will not be regulated. Is that right? Yes. For cross-boundary vessels, because we have amended the definition of seafarers and also provisions for recruitment, there will be some positive impacts on these vessels. Thank you. Mr. Sin Chung Kai, I have two questions. The first is about implementation of the MLC. The assistant or the PS told us that every areas under the convention have been covered. I'd like to know, is it really the case? And for some items, will we only be following, say, 90 or 80% of the requirements? Can a paper be given to us to show the discrepancy with the MLC? And direct reference approach, do we have any precedent? I understand what you mean by direct reference approach. You're saying that any amendment to the MLC will automatically apply in Hong Kong. But then from a lawmaking point of view, another jurisdiction is enacting laws on our behalf. I'd like to know whether we have any precedent when it comes to international conventions. Because the effect is, in future, laws may be enacted without LegCo's endorsement. Can we be told of the pros and cons of this approach? Why can't we adopt a subsidiary legislation approach by negative vetting? We can also do it quickly. Ms. Chen? Thank you, Mr. Xin, for your question. First, the use of direct reference approach. It has been used in other pieces of legislation. For instance, CAP 1.3, merchant shipping control and prevention of pollution ordinance to prevent pollution caused by merchant ships. I think Mr. Xin thinks that laws will be enacted on behalf of Hong Kong. Now, we only talk about very technical amendments. For instance, the amendments to subsidiary legislation to be presented to LegCo. For instance, we are talking about the width or length of beds for seafarers and the relative position. These provisions are very not really controversial, and if the requirements are universal, then they will be enacted in this way. But when we submit amendments to the relevant subleg, we will make note of areas where this approach will be used. But there are certainly precedents. When it comes to shipping, many of the provisions are very detailed and technical and numerous. Even if we use the subleg approach, we usually had to take a long time to revise the subleg. And we usually, when we are required to fulfill changes in international conventions, then the time frame is rather short. I think Mr. Sin would like you to present a table for the areas where you're not following the requirements of the MLC, and also please give us a table of items where the direct reference approach will be used. Chairman, may I go back to the first question? Of course, I know all the areas will be covered, but there might be departure from the requirements. So instead of 2, it may be 8. So can you please tell us where the requirements in local legislation is a departure from that in the MLC. Well, we have gone through the requirements in the MLC point by point, so it has taken us quite a while. We cooperate very closely with Government Council, and there should be no departure. Otherwise, we won't be able to fulfill the requirement of the MLC, and that would tarnish the reputation of Hong Kong. And when we enact subleg for each and every item, we will list all the items out. But of course, if the chairman would like us to explain in greater details, well, since Mr. Sin has requested it, because you said that for some items you would adopt the direct reference approach, for some you're not going to do that. So can we be given a paper to tell us items where the approach will be used? I am referring to other pieces of legislation, and I don't think the government always adopts the direct reference approach in making subleg. For instance, we are now working on one about pesticides and that are prohibited, and there is subleg to specify pesticides where a license is needed, and pesticides that are totally prohibited. So, Government Council, do you have any policy as to what items would qualify for this approach and what not? Thank you. May I submit some background information in response to Mr. Sin Chung Kai's question? Now, we are going to amend Cap 134 to allow the use of direct reference approach in making subleg under the ordinance in future. This will enable the administration to do so where appropriate. That doesn't mean that in future, for implementation of international agreements, we'll certainly use this approach. As rightly pointed out by Mr. Sin, this approach is not appropriate for each and every case. For the convention in question, not all 14 areas is suitable for the use of this approach. Now, in some areas, individual jurisdictions are allowed to make their own measures in order to suit their local circumstances. So, in this case, the direct reference approach is not useful. But in other areas, such as accommodation of seafarers, there are some requirements that are very detailed. For instance, if it is a single room, then the exact dimension of the cabin and also the size of the bed are specified. There is no room for us to tighten or to relax the requirements. Well, in such a case, we believe using this approach will be efficient, and any amendment can be made very expeditiously and in a timely manner. So we will consider whether the approach is really suitable. We do not use the same approach for all international agreements. As pointed out by Mr. Sin, that's very correct. But when it comes to legislation on merchant shipping and seafarers, for instance, 413, prevention and control of pollution, and Cap 369, safety of merchant shipping, there is subleg very technical in nature, where the standards are very straightforward. We have used this approach, and I can also provide examples where direct reference approach is used for members' reference. Mr. Alan Leung, I'd like to follow up on Mr. Sin's question. So, listening to the DOJ's explanation, it appears that it's for the executive to decide whether the approach should be used or not, and the LegCo has no say. If is it for the sake of conserving paper that the administration has decided not to print out all the very detailed and lengthy requirements for scrutiny, or is it for the sake of time saving that you've decided to do that? Now, if you tell us that it is for the sake of the environment, at least there is a justification. Otherwise, taking away the power from this council. Otherwise, you are removing the power from this council as to when and how international agreements should be adopted in Hong Kong. Ms. Chen, yes, it's LegCo's decision as to what requirements should adopt the direct reference approach, because we will list out in the bill for LegCo's scrutiny, and when we present the subleg, we will allow members to decide whether the direct reference approach is appropriate. Will they be really about the dimensions of bid, as pointed out by the Government Council? By then, the administration will be able to decide. Well, that's better, because I have never encountered this so-called direct reference approach. So you are saying that whether the approach will be adopted can be considered in the subleg, and then through our legal services division's report will be able to know whether a certain item will be dealt with using that approach, and if necessary, we can single it out for our consideration. Yes, if members do not agree to the approach, of course we have to amend it and list out the requirements one by one. The power or the say rests with the council. So when now the proposed amendments are very long, it's just that for items that are very meticulous and detailed, we are suggesting that perhaps the direct reference approach can be used. Can the legal advisor tell us the views of our legal services division? Now, when we received the blue bill, there will be a provision with reference to the MLC. Is it true that we won't be able to see the requirements ourselves? So it is do we have to have the hard copy of the MLC for comparison, so that afterwards we can decide whether the requirements are suitable for incorporation by reference? Is that the case? What are the procedures? Now, first, how can we know in the first place? Do we have to have a copy of the MLC first? I'd like to know whether direct reference approach is the same as direct incorporation by reference. Legal advisor. This approach has been adopted in the past, usually in very detailed, complicated international agreement provisions for technical reasons or for the sake of simplicity. The requirements are not included in our local legislation, but by means of reference to the agreement concerned. And I think in this case, the use of this approach will be for making subsidiary legislation?
When it is applied to subsidiary legislation and by means of negative vetting, members, when studying the subsidiary legislation, can also make comments and move amendments. By then, the administration will have to provide the relevant provisions in the International Convention for members' reference and for adoption. Members, in studying the subsidiary legislation proposals, can consider whether the direct reference approach is appropriate. Chairman, probably I have not fully woken up. I still don't understand the point. I just want to visualize how it will happen. Generally speaking, when we receive a bill, the bill will have all the relevant provisions. By means of direct reference approach, what will the text be like? What will be the text like? I cannot visualize that. Thank you, Chairman. Sorry, speaker is not coming through. Not all the provisions will be in the bill under the direct reference approach. The provision, which is the reference, or the things that to be referenced, is not in the bill. It will be in another copy. Now, if you use a direct reference approach, then say there is a provision, say which part, which section, from which to which section will be adopted into this section clause of the bill. Is it the approach? Ms. Chung. Let me provide some information for Mr. Leung's reference. As for the direct reference approach, there are different ways of drafting it, or drafting the provisions. As for this convention, the direct reference approach will just be limited to the subsidiary legislation. In the empowering provision, we say, we propose that the direct reference approach can be used in subsidiary legislation. So it's only be under the subsidiary legislation of Cap 478. Let me give you an example. Say under the convention, there is a requirement on crew accommodation with regard to the size of the accommodation. Say with reference to the accommodation requirements, it will have to comply with a certain section and subsection of the MLC. So we have to comply with the provision of a certain of the convention, and members can make reference to that. If it is just a framework, if it is not adequate, then we may not use that. But if it is just about details, then members may find that difficult. Members may find that appropriate. If it is as what the representative of the DFJ said, we can see that convention section N subsection X has to apply. Now, if we read the provision of the convention and finds that we need to amend it, then according to our procedure, we will take out this provision. According to the representative of the DFJ, the wording is something like that. ships registers in Hong Kong, which ships registered in Hong Kong is required to provide accommodation to seafarers with reference to, say, a certain section of the MLC. Now, if we are to amend it, how can we amend that? Because the wording is very simple. Say the accommodation has to comply with a certain section of the MLC, full stop. Having read the convention, we find that standard not acceptable. How are we going to change that? Because the provision of that part is the provision is so short. How can we change that part? Ms. Chang, the example I gave just now was only an example. The actual wording may be different. If we are to amend it, there are certain restrictions. We've signed the convention, we have to comply with the convention. If we are to amend that provision, it would be like that. Now, we have this empowering provision. When we use the direct reference approach, we can also do some local adaptation and local amendment. I don't know whether it is Cap 503 concerning the international exemptions. There are many conventions on that. We do have some amendments here and there. Our local amendments and adaptations are listed in a schedule. Say a section, certain section of the convention applies, but it has to be subject to certain conditions in the schedule. If there is any amendment, it really depends on the actual situation. Chairman, I think that may, or we may not be able to get an adequate reply today. Maybe the administration can produce a paper and explain that. I hope the administration understands why we are so anxious about it. This council is responsible for guarding the goal. This council is a gatekeeper with regard to local laws, and if we just say a certain convention applies here, lock, stock, and barrel, that will not do, because no country will do that. No country will allow that. We are the gatekeepers, and we need to be careful about the enactment of laws. Now, this is an empowering provision. We have to know what kind of power will be given out. And once it is given, it is given. It is water under the bridge. Will you be able to meet the requirement of Mr. Leung? Yes, we will produce a paper on the direct reference approach. Mr. Tang, and then Mr. Sin. We have to comply with the international convention, but the convention only provides the minimum standard. Say, if we want to provide for something that is better than the convention, then how can we do that? I have asked what in the convention has not been included in the local legislation. There's a lot of things in the convention. I just want to know what in the convention are not put in the local law. As for river trade vessels and also cross-boundary ferries, seamen are not covered by this provision, this bill. But you also say that they are looked after by Cap 478. I'm a bit confused then. Have you ever explained to the ship owners and seafarers of cross-boundary vessels as to how this bill applied to them? Who is to answer the question? Thank you, Mr. Tang, for the question. In 2007, we set up a tripartite committee. We have representatives. We had representatives from ship owners, seafarers unions, or sailors unions, and also representatives of the Labor Department and Marine Department. And we all understand the coverage of the convention. There are representatives from high-speed vessels. They know that the convention applies only to international voyage. Now we have the definition of seafarers, and seafarers do cover masters and other seamen, under Cap 478. So it therefore covers the cross-boundary ferry service as well. And the seafarers organizations can also do recruitment and placement, and that applies to cross-boundary ferries as well. The seafarers organizations can recruit sailors for cross-boundary ferry service. That's exactly the point. Now, let me give you an example. With regard to the shift arrangement, the seafarers or the sailors have a 24-hour shift. That is, they work 24 hours and then they rest for 24 hours. And that attracted a comment from the Commission of Inquiry. Now, in the bill, the requirement is just working for 8 hours for international voyage. So why there is a difference? There are different provisions for international voyage and different provisions for cross-boundary service. Now, the ocean-going liners or ocean-going ships are operating in a different mode. Say, for example, the sailors may work on board for several months on board. And we need to have provisions to deal with that in order to protect the sailors on board. They need to have adequate rest. We need to protect their health and safety. And we also need to protect the safety operation of the ships. Therefore, the MLC applies to all ocean-going ships who are doing international voyage. Now, as far as the sailors' organizations concerned, do they know that the bill doesn't apply to them? How can you avoid a sailor challenging you in a court, in particular those working on on cross-boundary service vessels? They may say that I don't care as long as I work on board, whether it's a seafarer in the ocean-going ship or a cross-boundary ferry, it should be the same. Now, with regard to a high-speed ferry, there is a permit required, and under the permit there is an appendix. And there are provisions on the working hours of the sailors. As for the seafarers, if he works for a day, his maximum working hour is no more than 12 hours, and he will have 1 full day rest after working for 2 working days. And if he works for 4 days, then he should have 2 days of rest.
Another thing is about senior seafarers such as the captain and the coxswain, the engineer, well, usually they work no more than 12 hours daytime and no more than 8 hours nighttime. And they have all the requirements or provisions about meal breaks in the appendix. For instance, whenever they reach a destination, there should be 15-minute break between 2 voyages and also 45-minute breaks between voyage in nighttime. And there are also specification on meal breaks. And Mr. Yek asked whether we know these ferries or vessels have followed the appendix. Now, for ship owner company, now this is May, they have to work out the roster for June, and the rosters will have to be submitted to the Marine Department to see whether the shifting arrangement is in line with what's set out in the operating license. And in June, when towards the end of the month, the report has to be submitted to us to see whether the shifting arrangement is really in line with what was submitted to us before the month. And so we have a mechanism to ensure that seafarers are working according to what is specified in the appendix to the operating license. Now, you issue operating licenses. I'd like to know whether you will directly or indirectly require the working conditions to comply with what's in the MLC. Also, because the MLC doesn't apply to cross-boundary ferries, so it's open to negotiations between seafarers and ship owners or operators. So do you understand what I mean? Will these vessels be entirely exempted from the convention, or we try to align the conditions of the two groups of seafarers using the operating license as far as possible? Well, we've made it very clear in the bill the scope of the MLC, all ocean-going vessels. So this is already ruled out. The cross-boundary ferries. I know Mr. Yik is concerned about the welfare of the crew working on such ferries. Well, as the Marine Department explained, there's a separate mechanism. So the aspirations of local seafarers and also ship owners in Hong Kong will work out an arrangement acceptable to both parties by negotiation. Any other question, Mr. Yek? Well, I hope that we can meet deputations. We will decide later. Mr. Sin Chung Kai. Now, I'm not hair-splitting, but I just want to sound a word of caution. Ms. Zhang said that the direct reference approach will involve adaptation. Well, when it comes to adaptation, there is no compromise. The role can only be played by electrical. Now, direct reference approach means that the requirements will be directly copied to our subleg. Now, I am not too familiar with current cases of direct reference approach, but I'm a bit skeptical, or rather, I am rather resistant towards this approach, because lawmaking should be done by this council. I agree that Hong Kong has the international obligation to comply with international agreements. However, local legislation should consider the implications to Hong Kong when it comes to the implementation of international agreements. Now, we are like a steward. If there is adaptation in any way, well, can our legal advisor help us. Whether there are already precedents. Well, I think the administration mentioned some. Legal advisor. This approach has been adopted for the implementation of some international agreements. Whether it is appropriate in this bill, I think members should consider it later. What are the ordinances involved? Well, I think that's mentioned in Para 9. Merchant shipping prevention and control of pollution ordinance, for instance. Mr. Sin, I'm done already. I just want to say that if the administration is planning any kind of adaptation in using the direct reference approach, then I have reservation. I'm not against the use of direct reference approach, but if there is any modification involved, I won't accept it. Ms. Zhang. Thank you. Let me provide some background information. We mentioned modifications, and Mr. Len Leung asked how that will be done. As I explained, when we use the direct reference approach, members will still see the requirements in the subleg. For instance, for certain requirements, please make reference to a certain subsection of the International Convention. And some local adaptation or modifications may be allowed. There will be subleg where modifications are made in the light of local circumstances. However, such modifications will be obvious to members. Will have to note in the subleg such modifications. So we will not just ask members to pass something that they cannot see beforehand. Mr. Sin, for the question, no. So I think the concerns might be different. Mr. Sin is concerned about the lawmaking authority of this council. He's worried that that might be compromised, and some international agreements might be introduced to Hong Kong using this approach without logical scrutiny. And the administration's position is for very technical provisions that may be changed from time to time. Well, I was a seafarer myself, and I understand that some requirements are really very technical. For instance, the accommodation, the dimension of cabins, and also even the number of washrooms. These are very technical. For instance, if the requirement for the provision of washroom is changed, there should be one more washroom. So the administration is thinking whether it is appropriate to submit a piece of subleg to amend that. So I think more justifications needed from the administration. Mr. Sin Chung Kai, of course, I am not as conversant as you are in this matter. I was never a seafarer, but will international conventions be amended so frequently? It will only take a few years of negotiation, and I think amendments will only be done once every few years, or perhaps they have technical subcommittees, but I doubt whether they have the time to change the requirements so frequently, to the effect that we have to use the direct reference approach. And you have to bear in mind that it's not easy to convert or alter ocean-going vessels so easily. Well, the vessels are at sea, so alterations or additions can only be done when they are at dock. Well, I agree with you, but usually they provide an exemption for vessels built before a certain year. Exemption will be granted. All right, we'll give the floor to Mr. Yik, or the administration would like to respond first. Thank you, Mr. Sin, for your concern. We do attend regular meetings of IMO in London to review and to amend the MLC. So they have 3 meetings in 2 years. So they really have technical amendments, and usually there is a grace period of 18 months and tacit acceptance of members is expected. And after 18 months, the requirements on safety and other things were applied to all vessels. And they always provide exemption and a grace period. The new requirements would not apply to all existing vessels because that would affect commercial operations. So usually they will not affect all vessels as far as possible. Mr. Yik. In principle, I support the administration because I think usually the MLC have better protection for seafarers than local legislation. And they will meet from time to time, and the amendments will usually improve the welfare of seafarers. So if we have to pass subleg every time after the meetings, that would be rather cumbersome. So I support the administration. Any other questions for the administration? If not, let's deal with Mr. Tenkapiu's proposal, and that is to meet with the industry to consult them. Any comments or objection, please? So we all support that proposal. So let's fix the date for our next meeting, and we invite deputations to meet with us. There are 2 dates for you to choose, the 28th of May at 2:30 and the 6th of June at 4:30. Which slot is better? I'm out of town on the 28th of May. What about the other 2 members? Well, what about the 6th of June? It would be better. All right. No, I'd like to know the time for the 6th of June, 4:30 in the afternoon. Uh, 28th of May is fine for me, but I'm not sure about the 6th of June. Well, so long as you have a quorum. Perhaps after the meeting, the Secretariat will consult members of the BC, and let's go for the let's go for the data preferred by members. And we invite stakeholders, well, associations, organizations from the industry, and also academia. Well, the 6th of June is fine. All right, then we will not sound our members' views. We'll fix it on the 6th of June, okay? Any other questions, please? If not, meeting is adjourned. We'll meet again on the 6th of June.